In the day's other headlines, a federal judge has dismissed President Trump's $10 billion defamation lawsuit against the publisher of the Wall Street Journal for a story on the president's ties to the late convicted sex offender Jeffrey Epstein. That article from last summer centered on a sexually suggestive letter written for Epstein's 50th birthday that appears to bear Trump's signature. The president denies writing it. The ruling marks the latest setback to the president in his efforts to manage fallout from the Epstein files. Mr. Trump's legal team said they would refile the suit.
Let me walk you through something that went down on Monday, April 13th, 2026. A scene that would have shocked anyone in past American presidencies, yet now feels almost ordinary. The current president of the United States watched a massive $10 billion defamation lawsuit get tossed out by a federal judge. This wasn't some minor dispute or everyday court battle. It was a huge $10 billion claim aimed at one of the biggest and most influential newspapers on the planet, the Wall Street Journal, owned by Rupert Murdoch, who's been a major media supporter throughout Trump's political journey. And it wasn't just dismissed. The judge's wording was so sharp and direct that anyone following Trump's legal battles with the press needs to pay close attention. Judge Darren Gales from the U.S. District Court in Miami and appointed by Obama decided that Trump's filing fell far short of the high bar a public figure must clear to prove defamation. He used the exact phrase, "nowhere close," quite the opposite. What made the decision hit even harder was exactly why it collapsed. The Wall Street Journal had reached out to Trump for his side of the story before publishing. Trump pushed back and denied it. The paper printed his denial right there in the article. The judge ruled that doing this showed the journal wasn't acting with malice. They were simply practicing real journalism. By giving the person a chance to respond and then sharing what he said, they proved they weren't recklessly ignoring the truth. So including the denial actually helped kill the lawsuit. Are you kidding me? This is crazy. Can you even wrap your head around it? Let's break it all down layer by layer. This whole thing revolves around a Wall Street Journal piece from last year about an alleged letter the then soon-to-be president supposedly sent to Jeffrey Epstein in 2003 for his 50th birthday, part of a so-called birthday album. Imagine the letter. It had a sketch of a naked woman and the line, "Happy birthday, and may every day be another wonderful secret." Trump has insisted from day one that he never wrote it, calling the whole thing fake. When the Journal ran the report, he hit back with a defamation suit. But today's Miami federal court ruling says the case can't move forward because it failed to show actual malice. So is this the end? Or can Trump appeal? Technically, yes, because the judge said the filing didn't meet the actual malice requirement. To see why this dismissal is bigger than just today's headline, you have to look at the bigger picture of Trump's media lawsuits in his second term. This isn't one random loss. It's a key moment in a wider push that's seen both victories and defeats. Trump entered his second term with a very deliberate plan against the press: file big suits, force settlements, and use the threat of long, costly legal fights to make unfavorable coverage riskier. He got a $16 million settlement from ABC News after suing over comments tied to the E. Jean Carroll case. He settled with CBS News, too. He sued the New York Times, quickly dismissed and sent back for refiling, sued the BBC, and in July 2025, right after the Journal's story on the Epstein birthday letter supposedly signed by Trump, he launched this $10 billion lawsuit against the Journal, Rupert Murdoch himself, the CEO Robert Thompson, and the reporters involved. Legal experts told CNN they couldn't remember any sitting president ever suing a major outlet like this before. It wasn't just tough legal action. It was a full-scale escalation of the media conflict that's defined much of the second Trump term. And on April 13th, 2026, a federal judge ruled that the biggest example of that strategy didn't even come close to clearing the legal bar. Let's dig in deeper. The Journal article that sparked everything is important to understand in detail. In July 2025, the paper reported on a sexually suggestive letter they said carried Trump's signature. It was part of a 2003 birthday album put together by Ghislaine Maxwell for Jeffrey Epstein's 50th. The letter reportedly featured a drawing of a naked woman and that birthday message about wonderful secrets. Trump called the story completely false, malicious, and defamatory. His team said the letter never existed and was made up. He threatened legal action almost immediately. Then, less than 2 months later, the House Oversight Committee released the actual album they'd subpoenaed from Epstein's estate, and it included a letter that matched the journal's description exactly. Trump's side kept denying he wrote it, saying the wording and sketch weren't his. But the letter was real, the album was real, the journal's details lined up with the public records, and the $10 billion defamation suit kept rolling through late 2025 and into 2026, until Judge Gales shut down round one this week. The real test for this lawsuit was always the legal bar Trump had to clear, and that's where the dismissal packs the biggest punch. Thanks to the Supreme Court's 1964 New York Times v. Sullivan decision, a public figure can't win a defamation case just by proving something was false. They must show actual malice, meaning the publisher either knew it was false or acted with reckless disregard for the truth. This high bar was created on purpose to safeguard press freedom and stop powerful people from weaponizing lawsuits to silence stories they dislike. It's an especially tough standard when the plaintiff is a sitting president suing a major paper over reporting on his ties to a convicted sex offender. Trump's filing needed to credibly claim that the journal knew the birthday letter story was untrue or published it anyway without caring if it was accurate. Judge Gales said it didn't even come close, and his wording was crystal clear. He wrote that the complaint fell nowhere close to the standard for actual malice, quite the opposite. He highlighted facts that actually hurt Trump's malice claim. The journal's team contacted Trump, Justice Department officials, and the FBI before publishing. Trump gave his denial. The DOJ stayed silent. The FBI declined comment. The paper ran Trump's denial in the story itself. The judge summed it up. In short, the complaint and article confirm that defendants attempted to investigate. The journal tried to get all sides, published Trump's denial, and let readers decide. That is not reckless disregard for the truth. It is journalism. He noted that the evidence Trump himself provided actually worked against the malice argument. The complaint used standard, generic claims of ill will without the detailed, specific facts the actual malice rule demands. Formulaic accusations aren't enough to keep a $10 billion case alive past a motion to dismiss. Importantly, the judge never decided if the letter is real or not. He made clear that questions about whether Trump authored it or was Epstein's friend are factual issues for later stages. He wasn't saying Trump wrote it or that the journal was 100% right. He was saying the complaint, as filed, didn't properly allege that the journal knew the facts were different and published anyway. It relied on vague language instead of concrete details. So, dismissed without prejudice. Fix it and refile by April 27th if you can. This dismissal fits into Trump's larger media lawsuit playbook, which isn't just one case, but a pattern with mixed outcomes aimed at multiple goals at once. The ABC and CBS settlements, over $16 million combined, proved some outlets will pay up to avoid a long fight with a sitting president. But the Journal, the Times, and the BBC refused to settle. This ruling shows the strategy hits limits when it faces outlets with strong legal teams, big resources, and a commitment to fight on First Amendment grounds. The Sullivan Standard is there to stop powerful figures from chilling journalism with defamation suits, and it worked exactly as intended here. President files a $10 billion suit, judge applies the law, complaint doesn't measure up, case dismissed. Trump's Truth Social post after the ruling was surprisingly calm. He wrote, "Our powerful case against the Wall Street Journal and other defendants was asked to be refiled by the judge. It is not a termination. It is a suggested refiling, and we will be, as per the order, refiling an updated lawsuit on or before April 27th. His legal spokesman told CNN the team would follow the judge's guidance and refile what they called a powerhouse lawsuit to hold fake news accountable. That's standard legal team spin after a without prejudice dismissal, framing it as helpful advice rather than a loss. But the gap between their words and the judge's nowhere close, quite the opposite, is huge. One extra detail worth noting. In March 2026, while the $10 billion suit against Murdoch and the Journal was still active in court, Trump recorded a video for Murdoch's 95th birthday party, calling him legendary and praising his courage, vision, and determination. That's not typical behavior when you're suing someone for $10 billion over Epstein-related coverage. It hints the lawsuit might have several aims at once, putting pressure on the Journal's reporting, keeping the birthday letter debate in the spotlight, and possibly opening the door for a settlement. The Journal isn't backing down, they're fighting. April 27th is when we'll see what the next version looks like. This ruling doesn't exist in a vacuum. It landed the same week as the ongoing congressional battle over the Bondi subpoena in the Epstein files. The same week Melania made her surprise White House statement, right in the middle of the Iran ceasefire, the collapse of Islamabad peace talks, the new U.S. Navy Hormuz blockade announcement, the tariff refund disputes, and the war powers deadline approaching April 28th. It's just one setback in a second term packed with more legal fights than any modern presidency. The Supreme Court struck down IEEPA tariffs. Over 150 court orders have blocked administration moves. The DOJ's subpoena attempt on Jerome Powell was rejected. The Larson impeachment filing sits in committee. And now this high-profile $10 billion media suit has been thrown out for missing the legal mark. Each of these creates political heat and raises the same core question. What are the real limits on this administration? And what happens when they're tested? 4 key takeaways from this WSJ dismissal and why it matters way beyond the headlines. First, it highlights the built-in clash between Trump's aggressive media lawsuit approach and the First Amendment protections designed to stop powerful people from using defamation law to muzzle the press. The actual malice standard from Sullivan is intentionally high. The Supreme Court set it that way in 1964 because anything lower would destroy press freedom. Judge Gales applied it exactly as written and found Trump's complaint didn't come anywhere near it. Reaching out to Trump, printing his denial, and letting readers judge isn't malice. It's textbook journalism. No matter how many settlements Trump gets from outlets that can't afford the fight, Sullivan remains the constitutional line that protects those willing to stand their ground. Second, the April 27th refiling deadline is the immediate next step. It will show whether Trump's lawyers can craft a new complaint that actually lays out specific facts proving actual malice, not just repeat the same vague claims. The judge didn't settle whether the letter is authentic. He left those facts open. The real issue is whether they can plead concrete details showing the Journal knowingly ran false info or recklessly ignored the truth. Since the paper followed standard procedure by contacting Trump and publishing his response, the road to a stronger complaint looks pretty narrow. The judge's formulaic claims and nowhere close language wasn't an open invitation for minor tweaks. It signaled deep problems with the legal theory that extra details might not solve. Third, this connects straight to the bigger press freedom battles of the second term, with ripple effects far past this one case. Trump has used expensive lawsuits as a tool to make critical coverage costly and risky. The ABC and CBS payouts showed some outlets will choose to pay rather than fight. But the Journal's choice to battle it out and win a clear dismissal sets a new example. It proves the sitting president's defamation suit can be rejected on straight legal merits by a judge who follows the law without political favoritism. That's a powerful message for every newsroom facing or expecting Trump legal pressure. Sullivan still works. Courts will enforce it. And outlets that fight instead of settle may end up in a stronger position than the administration's tough tactics suggest. Fourth, the timing makes it especially painful for an administration that's been using this lawsuit to manage the Epstein files narrative. Trump filed it days after the Journal's July 2025 story as a way to push back and signal consequences for the reporting. Now the suit itself has been publicly rejected, with the judge saying it was nowhere close. The Journal doubled down on its reporting's accuracy. Meanwhile, the Epstein story, the birthday letter, the congressional fights, Melania's statement, the Bondi subpoena drama, is hotter than ever. The very lawsuit meant to bury the story has instead kept it alive, given the Journal a public win for its journalism, and added another court defeat to a second-term record that's stacking up losses at a record pace. Bottom line, on April 13th, 2026, a federal judge tossed Trump's $10 billion defamation suit against the Wall Street Journal with some of the strongest language possible. Nowhere close, quite the opposite. The Journal stood firmly behind its work. Trump's team called it a powerhouse case and promised to refile by April 27th. The Epstein birthday letter, the one Trump denies writing, the one Congress released and that matched the Journal's description, is still an open factual question, with the judge deliberately leaving it unresolved. Every part of this keeps moving. The refiling, the congressional Epstein fights, the wider media litigation push, and the unanswered questions about what that letter really says about Trump's past ties to Jeffrey Epstein. Zooming out, this is part of Trump's all-out war on the media, and the WSJ case is the clearest window into why it matters. His second-term legal offensive against news outlets is creating settlements in some places, court losses in others, and permanently changing how the White House and the press interact. The settlements, like the $16 million from ABC over the E. Jean Carroll comments, with money going to Trump's foundation, send a loud message. If your company has regulatory risks, broadcast licenses, or just doesn't want years of expensive fights against someone with unlimited resources, paying up can look easier than battling. CBS and Disney cut their own deals too. The pattern of outlets choosing accommodation over confrontation is real, but the Journal, BBC, and New York Times refused to settle, and that's why Sullivan's actual malice standard is being tested and upheld in court right now. When outlets fight, the law kicks in. When they settle, the chilling effect grows. The WSJ dismissal gives every newsroom watching proof that federal judges will apply Sullivan strictly, even against a sitting president. The most expensive, highest-profile defamation suit ever filed by a president in modern times was thrown out because it didn't meet the standard. That's a major signal. There's also a broader First Amendment angle linking to other administration efforts to pressure the press. FCC threats over Iran coverage, Trump labeling CNN reports 100% fake news, and defense officials pushing more patriotic framing. These aren't random, they're coordinated tools. Lawsuits, regulatory warnings, public attacks, and quiet rewards for friendly coverage. The WSJ ruling blocked one piece of that strategy, reminding everyone that you can't weaponize defamation against normal journalism that includes responses and lets readers decide. But the other pressure tactics continue unchecked. The Epstein link can't be ignored either. Trump sued right after the Journal story, denied everything, and called it fabricated. Congress later released the real album matching the description. The lawsuit continued, and now, in the same 2 weeks that saw Pam Bondi fired over Epstein file handling, Melania's surprise statement, escalating subpoena fights, and more document releases, the flagship legal challenge to that reporting has been dismissed with a blunt, nowhere close. The Journal is standing tall. The birthday letter story that launched the $10 billion suit has now been publicly bolstered by a federal judge in a way settlements never could have achieved. By choosing to litigate, Trump actually drew more attention to the letter than the original article ever did. Not exactly the result they wanted. Final takeaway. The WSJ dismissal landed on April 13th, 2026, right in the middle of a chaotic week with the tax deadline, collapsed peace talks, and the Iran war powers clock ticking. It's one piece of a storm of legal and political challenges testing this administration on every front at once. The courts are holding the line. The Sullivan standard stood firm. Judges are applying the law. The clear message from courtrooms nationwide on tariffs, immigration, firings, and defamation is simple. No one, not even the president, is above the law. When filings don't meet the standards, they get dismissed. We'll keep following every twist in the WSJ refiling on April 27th, the Epstein files battle, and all the other legal fronts in this second term. Subscribe, turn on notifications, and join the free newsletter in the description so you never miss a beat. This story is moving fast, and you deserve to stay ahead. See you in the next one. April 27th is coming. Keep watching this space.